27 of the 2025.
Present transfer petition stands dismissed.
May it please, Your Lordship. May it please, Your Lordship.
Yes, yes, he says something, yes.
I get to mention item number 18, Lordship. In this case, my Lord, interim is there, Lordship, but CD receipt not up to date, Lordship.
CD not yet received.
Receipt, but not up to date.
Accused statement is not recorded. Last time it was sent for updation, but it is up to 26/03/2025, and the petitioner has granted interim on 14/5/2025.
14/5.
Yes,
And last entry is there,
23,
23,
26/03/2020.
2603.
The petitioner is on interim also.
See, it was simple. Heard Mr.
M1.
M. Mondal, the learned counsel for the petition, also heard MS S.H. Bora, the learned additional people, the brain on behalf of state respondent. It is submitted by MS Bora that the CD is received, but same is not up to date. And the last entry in the CD is on of 26/03/2025. And the petitioner got the interim anticipatory bail on 14/5/2025. In view of this, later updated case diary be called for, accompany the statement of the accused petitioner if already recorded. Listing matter recording the
On 21/07.
21/07/2025. Interim be continued till new set of listing.
May I please, Your Lordship, for listing the
Listing, no, no.
earlier,
not the-
earlier rejected the
No, no,
honorable
we are not taking the regular bench. You make a mention before registry only. If registry allows them 2 days left, we are also taking only the motion matters. Earlier rejected, maybe you approach the registry, it may be listed before this court. Approved.
Motion, item number 1.
May I please, Your Lord? My lord, in this case, what happened? Two persons were caught red-handed by the police, my lord, in Karimganj district, my lord, while they are carrying the narcotic drugs. And after interrogation, my lord, the truck was seized, and I, being the owner of the truck, registered owner of the truck, my lord, I was taken into, though I am the owner of the truck, my lord, I am doing a pharmacy business. I am a pharmacist, my lord. I have handed over the truck to one, Fuzail Ahmed, my lord. That is the page 17 agreement from March 2024. And
But till now, you are the registered owner.
I am still now registered owner, but I have given him a rent, my lord.
Acha.
Agreed by that you will run it. But it is found that there was a chamber in this truck, my lord,
Secret chamber.
where these drugs were hidden. So my lord, those two driver and even said that I am the owner, and it is on my instruction they are running the truck. So my lord, I was taken into custody on 11/6, in spite of the fact that I have given a statement that this truck belongs to though me, but I have given him on rent to one Fazal Ahmed. But they have not listened, my lord. Now my only prayer before your lordship is that your lordship, there is a canon decision of the apex court and our high court that co-accused statement implicating inculpatory and exculpatory statement, my lord. There is a 2025 case, my lord. I am handing over to your lordship.
Now see, Mr. Biswas, yes, I can understand. Even Tufan Singh is also there.
Tufan Singh also I have brought, my lord.
Yes, this is there, but the
There are
question
three
is that
judges,
we are not in a position to say anything at this stage, whether exclusively on the basis of the statement of the co-accused he has been arrested
Yes,
or is
ma'am.
arrested, or there are any other
Material
material
thing.
against incriminating materials against
Your
him
lordship
during the
will
investigation.
That should be examined, my lord.
That has to be examined.
That's
So
right, that's right.
it is not a charge, it is an investigation case. Still under investigation, I think.
Yes.
Okay, then we calling it yes, because he is in custody. Tell us any date.
NDPS commercial quantity lordship.
No, that's what.
Yes.
The vacation only. We don't have any date now.
CD along with FSL report, it can be on lordship 21.
21 will be okay or 21.
There is one alternate.
2107 corridor for CD along with the FSL report. Okay, we're calling it. Then.
Item number 2,
May I please have Lordship? Here also, Lordship, scan focus may be called for, Lordship, that will be required, Lordship.
Is this a charge sheeted one otherwise?
Charge sheeted one, Lordship. The petitioner was arrested, Lordship, on the strength of one warrant, Lordship.
Okay. Scan copy of the TCR. It LCR ne likhibo, ha? TCR likhibo. TCR be called for along with the case diary. Yes, can it be listed when?
Lordship, just immediately after reopening. Can it
Your
be-
petitioner is in custody since 2002-2025
Yes, Lordship.
Lordship, can
on
it
the
be
basis of strength of warrant only.
Yes, Lordship. Nothing was
On
recovered
18th of-
from me, Lordship.
18/7?
18/7. Okay, 18/7. By listing it. Okay.
Fine.
3,
Yes, 3. One is here. This is a case of what nature?
Lordship, this is a paid application, Lordship.
And again, commercial quantity.
Yes, Lordship, commercial quantity.
None appears on call for the petition. List according.
The regular bill, Lordship.
Yes, we registry will fix the data.
No.
Otherwise it is a charge sheeted case or no? You are appearing on which item?
Item 3, Lordship.
Yes. Your petitioner is in custody since when?
2205, Lordship.
2205.
05.
Is it charge sheeted one?
No,
No.
Lordship. Charge sheeted.
Then we're calling for the case diary and the along with the FSI. When it can be?
Lordship on 21.
20. Okay. 2107. 21/7 as CD along with the case diary. Okay.
Oblige, Lordship.
None appears to কাটি দিব. Yes.
NDPS commercial quantity lordship. As on date, 139 days
139 days.
behind.
Not yet charge sheeted.
Not yet.
130 days is behind the burden. When it can be called for?
17.
17.
17,
Okay,
7.
17/7, 17. CDB call for along with the FSL report, 17. Okay.
5,
At least your lordship.
Yes.
The senior is on another call. Maybe.
I don't know. Okay, we have for the timing, we have keep it at timing, but
Timing.
I know because it's a, she's saying it's a commercial quantity case of
Yes.
nature is. Do you have any other instruction? Well, since when he is in custody or whatever?
He was arrested on 16/03/2025. Investigation still going on, Lordship. City along. with
No,
FSL.
do one thing, we can call for the case diary.
Yes.
Because it will be a simple order because without perusal of the case, there is a commercial quantity. We are not in a position to pass any order on bail at this stage. So we are calling for the case diary along with the FSL report. We'll fix the date.
On
Okay.
18.
18/7.
6,
Lordship, may pass over for the timing lordship.
Timing is a very thing for us. Okay, for 5-10 minutes we are
Yeah,
timing.
yes, Lordship.
Otherwise, we are not.
Thank you, lordship.
Okay.
7,
7, 9, 7.
7,
None appears on call for the petitioner. List the matter accordingly after petition. Yes.
8,
আপনি নোটিশ টু দিছিল তো নোটিশ টু দিয়া আছে
yes,
Item 8?
8 you are on 8
Yes, yes.
yes item 8
My lord, the FIR is page 9.
FIR is at page
9. Very long FIR. My lord, FIR has, my lord, given lot, my lord, after more than 1 month of the Alice incident, my lord. Oh,
after 1 month
more than 1 month. More than 1 month. Totally false FIR, my lord. Can you see the FIR? Very long FIR, my lord. I'm reading the FIR. Most respectfully, Bexo stated, I am poor and needy man. My wife and I work as.
so is 64 is there
Yes, Lordship. along with 8 of POCSO.
Yes.
Married.
Hmm.
সন্মান সহকাৰে জনাও যে মোৰ নাম সুমি গগৈ, বয়স 30 বছৰ। মোৰ স্বামী ৰাজা গগৈ, কৰ্মসূত্ৰে কেৰালাত কাম কৰে। মই ফেচবুকত সো নম্বৰ মোবাইল ফোনলৈ ফোন কৰি ৰাজু সোণোৱাল ওৰফে দিব্যজ্যোতি সোণোৱাল, ঘৰ লখিমপুৰ পহুমৰা গাঁৱৰ বুলি চিনাকি দিয়া বৰ্তমান হায়দৰাবাদত চিকিউৰিটি গাৰ্ড কৰোঁ বুলি কোৱা ল'ৰাজনৰ লগত চিনাকি হওঁ। তেওঁ মোক বিচৰা কিছুমান আপত্তিজনক ফটো আৰু ভিডিঅ' দিওঁ। উক্ত ফটো আৰু ভিডিঅ' স্ক্ৰীনশ্বট মাৰি বৰ্তমান মোৰ নামত গগৈ মামুন্নু চুমি নামেৰে ফেচবুক একাউণ্ট খুলি ভাইৰেল কৰি মোক জনমানসত সেৱা প্ৰতিপন্ন কৰিছে। ফলত মই ক'তো ওলাব নোৱাৰা হৈছোঁ। According to FIM, she herself has sent the photographs, off-screen photographs. Even
She's a married lady.
Well,
Married lady having a child.
made late for the fact is, but in the misuse of my online platform now, this trending is going on.
Yes, Bora. Heard Mr. A. Khanika, the learned counsel for the petition, and also heard MS S.H. Bora, the learned additional PP appearing on behalf of state respondent. Pakilihivo, this is an application under section so and so in connection with so and so. Next, considering the submission made by the learned counsel for the petition, and also considering the materials in the FIR, I find it a fit case to extend the privilege of interim pre-arrest bail till receipt of the case diet. Pakin Lihidiba, CD call call. CD when it can be called for.
Lordship,
CD when it can be
23rd.
23rd.
Yes.
Deep level.
23rd of July. Okay.
I being item number 9.
Made it off.
The prosecution section 732(1) and A and B says that if the tax evaded or tax availed and utilized.
Hmm.
Now, there is a division bench judgment of the Patna High Court.
Last week.
Which says, my lord,
Join us in it. Yes.
there is a judgment of the Patna High Court, my lord. This says, my lord, the tax can be availed and utilized only when it is utilized for reduction of the tax liability. Well, I will just pass over the judgment.
Mr. E. Gogoi is appearing in this matter.
Yes. Okay, you just remain present. Because they are hearing us also, if it hearing, then it will again come up before it.
Yeah.
Just remain present. He's just going to start. He has already, you are there on the last occasion also, I think so. So, entire submission has already been made by Mr. Sharaf that apart 2-3 points on the merit when he wants to submit. Don't make it so lengthy submission because we are not in a position to say here anything.
But
Anyway.
this is, after all, in revenue matters, my lord, you want to convince your lordship that, my lord, this I am entitled to bail, my lord.
Yes.
You also kindly see, my lord, page 65.
Page 65.
Fine.
Yes.
The last paragraph, my lord.
Hmm.
I have reproduced the relevant provisions of the so-and-so act, Bihar, my lord, it is Bihar cells, which finds mentioned in the discussions held in the reference. The legislative intent present in these provisions is eloquent, and I am of the confusion to hold that be it a charge of wrong availment or utilization, each is positive act, and it is only when such act is substantiated that it makes the dealer concerned liable for recovery of such amount of tax as availed from the input tax credit or utilized by him. But in each of the three circumstances, the tax available at the credit of the dealer concerned must have been brought into use by him, thus reducing the credit balance. A plain reading to the section so and so would confirm that only it is when such availment relation of the credit to reduce the tax liability. Now, in this case, as you also said, it is admitted, although we are not admitting, they say that whatever you have purchased, there was no purchase at all. Whatever you have sold, there
Those
was no
form-
sale at all. If there was no purchase and no sale, the question of the tax does not arise. If the question of tax does not arise payable, then the question of reduction of the tax liability by availing the input tax credit also will not arise. Thereby, both the conditions which are there in section 132, that it must be either tax evaded or availed or utilized input tax credit are not fulfilled. Secondly, Milord, I was waiting for him. Call him. Radhika Gala, call him.
Page 31, please.
Judgment.
Page 13 of compilation.
Milord, I was submitting for lordship on the last date, Milord. On the Radhika Gala, on 13 comes earlier. Only 35. Radhika Gala. Lord, I submitted on the last occasion, Milord. Then in the authorization to arrest,
Yes.
in the grounds of arrest, as well as in the complaint memo, Milord, it is not mentioned as to how the amount of 9.6 has been determined.
Yes.
Now,
Yeah,
in this
well,
connection, you'll also can see the. कौन सा था? Wherever. The judgment of the Radhika Agra. उठाना यार, उसमें होना पड़ेगा.
Compilation Radhika is there, I think.
My lord, my lord. Are you going to say, my lord?
Yes.
नहीं मुझे जनरल बेलो दिया नहीं. कौन सा है? At page 47, my lord.
Of your compilation, no?
Yes.
Compilation, article लिखिए उसमें फाल. वो department. मैं तो department लिखूँ. ये लोग की कोलप काम टू कोलप लाइन नोटे कोलप.
Yes,
Well,
47.
47, paragraph 59.
Mm.
However, relying on the judgment of so and so, it has been submitted on behalf of the petitioners that the power under section 5 or section 435 cannot be exercised unless the procedure under section 73 of the GST is completed and an assessment order is made quantifying the tax evaded or erroneously refunded or input tax credit wrongly availed. According to us, this contention should not be accepted as a general or broad proposition. We would accept that normally the assessment proceedings should quantify the amount of the tax evaded, etc., and go to show whether there is any violation of the so and so of the act, and that clause of so and so is attracted. But there could be cases where even without a normal order of assessment, the department revenue is certain that it is a case of offense under so and so, and the amount of tax evaded, etc., falls within the clause so and so of the cases. In such cases, the commissioner may authorize with sufficient degree of certainty. In such cases, the commissioner may authorize so and so to able to ascertain and record reasonable reasons to believe to indicate the above, the reasons to believe that explicit and refer to the materials and evidences underlying such opinion. So, my lord, the Supreme Court said that it is not necessary that the assessment in all cases has to be completed. but it must be on the basis of materials and evidence. The commissioner must come to a degree of certainty. उसके बाद क्या है? There has to be a degree of certainty to establish that the offense is committed, and thus offense is when non-bailable. So, my lord, the material of all the assessment was completed, but simply saying 9.6 crores or 4.6 crores is not sufficient. All the materials must be placed. How it has been determined, there must be certainty. This I was trying to guess the course. At present, only on bail, my lord, I am.
Yes.
Yes.
So, my lord, so far as the bail part is concerned, lordship may kindly turn to page 6 of the petition, criminal petition.
Page 6.
Yes, ma'am.
Yes.
Page 6, para 3, ma'am.
Hmm.
Only, my lord, on the point of arrest, ma'am.
Yes.
It says, my lord, that is a plea of the petitioner. It is relevant to mention that here mentioned herein that the respondent number 3 arrested the petitioner on the LS, allegedly being authorized to arrest without disclosing the details of reason to believe. That is the ground for arrest. What was the necessity in arresting the petitioner? The lordship may kindly have a look at page number 69. Whether it was disclosed or not, whether we have a ground or not, it was lordship, that will, my lord, that will be apparent from page 69.
69.
There is a ground of arrest dated 10/6/2025.
Yes.
May I read it, my lord? The short paras. An investigation was initiated in respect of Sif Traders, so and so, regarding alleged availment of ineligible ITC and passing on of ITC on the strength of invoices without actual movement and receipt of goods, wherein you, that is Varun Goel, is the sole proprietor and authorized signatory in response of signatory is responsible for the activities. Your statement was recorded on 9th of June 2025 and 10th of June 2025. Lordship will kindly mark it. Statement was recorded. I will place the statement where you have stated that you are the sole proprietor of the firm so and so, and on being asked about the availment of the ITC on the strength of invoices issued by non-existing entities, you were unable to give plausible reply. Further, on being asked about the non-movement of goods as per the RFID data analysis is regarding movement of the vehicles where goods are being transported. So it is there in this particular FRID. You were unable to substantiate that the goods were actually received by you. So there was no movement of goods, no goods was actually received. You also admitted, lordship will mark this word. You also admitted that you have issued invoices without actual movement of goods. What more is required? To various taxpayers, as per section 16(2)(b) of the GST Act 2017, read with relevant provision of the IGST Act, receipt of goods is a primary condition of availment of ITC. That is the input tax credit. The evidences, including e-way bill data and RFID toll pass record gathered during the investigation, has unearthed large-scale GST evasion around 9.9 crores by you and revealed that you so-and-so, the sole proprietor of so-and-so, is responsible for this GST evasion by availing ITC. Lordship will see that term. It is availing ITC 4.6 crores without receipt of goods. And my lord, next is issuing. One is availing, my lord, 4.6 and issuing invoices to pass on the ITC without actual supply of goods, that is 5.3. Now, my lord, 4.6 plus 5.3 is 9.9. On the last occasion, the statement was made from the side of the petitioner that, my lord, somewhere they are saying 9.9, somewhere they are saying 4.6, somewhere 5.3. 9.9 is the total figure. Availment is 4.6. The issuing is, my lord, 5.3. They are two separate things, my lord. You have committed an offense under section so-and-so, which is punishable under so-and-so. Therefore, your arrest has been authorized under section 69 of the so-and-so for the offense committed. My lord, here, from this particular, my lord, ground of arrest, apparently everything has been revealed. We cannot, my lord, place before the, my lord, petitioner all the things that we have investigated. But, my lord, that statement, my lord, if lordship wants to peruse, I can at least place it before the court. He has admitted, my lord. So that is, my lord, that's why he has been arrested. It's a different thing, my lord. He was arrested on 10/6. Now already 15 days have passed, and he is on judicial custody. No remand claim has been made by the complainant, my lord. Order. No, he can, so, my lord, if lordship one, I can place the, my lord, statement just for a. Lordship will see, my lord, I won't go by the entire, my lord, document, just to point out, my lord, the last, my lord, first page, last para, the bold one, my lord, highlighted part. I accept that these taxpayers issued only invoices without supply of goods, and I have claimed the input tax credit against the invoices. There are no actual movement of goods. These are the witnesses. Same way, my lord, in the next page. Last, my lord, last para. I also accept that I have issued invoices to various taxpayers without supplying goods. The outward invoices which I have issued, invoices involves a tax amount of rupees so and so. I have issued invoices to the taxpayers located in Arunachal Pradesh, Meghalaya, Nagaland, which involves IGST, that is integrated GST, tax liability.
16
Well, in the third page, where the highlighted part in the middle after the chart, I also agreed that I have set off all my outward tax liability by using ITC without any payment made in cash. No revenue has been paid. I also agree that I am doing this fraudulent activity, lordship will see, to get financial benefit from the transactions. I was getting commission, lordship will see, my lord, this commission for each transaction, which is approximately 0.4%. Now, last para. The aforementioned declaration has been made by me on so and so during the time of inspection of my business premises. This statement has been drafted by the state GST officials based on my request to draft the statement. The statement has been thoroughly read and understood by so and so. His signature is there, the witnesses are there. So, regarding bail, my lord, today, I think, my lord, this is enough, my lord. I leave it to your lordship, my lord, otherwise. From 10/6 is behind the bar. Then, my lord, that part I leave it to your lordship. On the merit of the case, lordship will definitely grant us some time. We'll contest the case.
No, obviously.
Only one thing, my learned friend has read the grounds of arrest. My lord, the lordship looks into section 69.
Yes, you can read. Move Peter doesn't even get caught. Book. No, book. And I have book from Peter. Move Peter doesn't maybe GST code. GST.
No, Korea is coming.
Yeah, there's no Peter.
That's one right.
Otherwise, you can supply it. I have book is in and my mind.
We always keep the extra book, my lord, because in different courts, the books are not available. Generally,
No, I have the book. This. Most probably it is in my chamber only.
My lord.
Oh, yes.
The lordship is
69.
69, lord. Where the commissioner has reason to believe that a person has committed an offense specified in so and so object, which is punishable under so and so or so and so act, he may by an order authorize an officer central tax to arrest such person. Reason to believe is to be recorded by the commissioner.
Yes.
And he has to authorize the authority to arrest. Therefore, lordship must see further, my lord. Where a person is arrested under section 3 for offense specified in so and so, the officer authorized to arrest such person shall inform such person the grounds of arrest and produce so and so. So, my lord, first of all, there must be reason to believe, then authorization, then arresting authority will record the grounds of arrest. Now, in lordship judgment, which your lordship has given me, earlier one, your lordship has said reason to believe is the first precondition. Reason to believe is the first precondition, thereafter authorization, thereafter grounds of arrest. Now, grounds of arrest, if the reason to believe is not there, the grounds of arrest has no meaning at all. Now, secondly, my lord, my learned friend has, although I not muted, but statements have made, it is admitted by the department also that there was no movement of the goods either from purchase or for the sale. Now, if there was no movement to the goods, then question of tax does not arise. Secondly, my lord, section 16 puts a bar that unless and until the tax has been paid,
Yes.
the input tax credit cannot be availed of. So if I have not paid the tax, the question of availing the input tax credit does not arise at all. Because if there is a limitation that the tax must be paid, then only someone can take the advantage of it. So if the tax has not been paid, the question of credit does not arise. These are on merits, my lord. My learned friend will file reply. My submission before lordship is that, my lords, the 41A, reason to believe, and the circular, my lord, as well as the judgment of the Patna High Court. My lord, on that basis, my lord, 15 days I am in judicial custody. My learned friend says that he has not been taken on remand. My lord, where they will take me remand? In the commissioner office, my lord. The commissioner office, the Supreme Taxes Assessing Authority has, my lord, arrested. There is no system of putting me in the police custody. It has to be kept in the custody of the
No,
Supreme
but they
Taxes.
have not filed any petition for any other custodial intervention in the jail premises also.
No, nothing. So my humble prayer before lordship is that, my lord, this is a case, my lord, which is a number of persons have been released on bail.
Take it up, DD. Take it up.
It was a pleasure arguing for lordship.
We are not hearing the matter on merit, in fact, only on the bail matters. Rest we will not discuss it.
Without observing anything on the merit part now.
No, I am only merit
The
only.
bail part, lordship may consider.
Merit only I follow for the purpose of
Because
admission.
we will file our affidavit, we will have to contest the case. This is
Yes,
under
yes.
investigation.
Yes.
So at this stage, my lord, something.
I merit only I submitted before the lordship to show the prima facie, my lord, case
Not
for admission. Otherwise, for bail, my lord, I am not submitting.
that statement, my lord, if I can take it back after lordship passes
You
the
want
order.
to take it
No,
back
no,
here?
Yes, lord, because this will be, my lord, something.
Give a copy, photocopy.
I have to give on the investigation also.
I don't know what is this.
No, lordship will keep
Okay,
it.
then otherwise from your submission, it has been things that he accepted, in fact.
That is the statement. In fact, it is there in the ground of NSL.
You accepted, my lord. Whatever they are submitting, we are not disputing that it was not made.
No.
They are also
Otherwise,
saying,
I'll hand it over back to you
Yeah,
after my order.
madam, after the order.
Okay.
they are also saying that goods have not moved. I also said that assuming goods have not moved.
Goods are not moved, it is admitted,
So
I
that's
think.
it. They want to say that goods are not moved.
That's the problem. That's the fact.
Yes, in the name of some fictitious
Yeah.
company and all.
Yes.
You know, in Assam,
And this is the first arrest under GST reason.
no.
Huh?
Both arrest is some arrest. The orders have been passed to bail. What GST first? And we are very back in rupee and all these things. They are
Yes,
doing
yes.
in 1,000 crore, 200 crores. We are only 8-9 crores right now. I am grateful to your lordship, my lord.
Okay,
But I think before vacation, I'll get the order, my lord.
we'll try to pass it by today or by tomorrow.
My lord, because
Maybe, may not be today, maybe tomorrow.
but so that at least in vacation he is not, my lord, at least. If I am successful, my lord, if I am successful, I am grateful to lord.
Okay. এইটো থৈ দিব লগতে অৰ্ডাৰটো ভাপটান কৰা আছে কম্পাইলেশ্যন আছে ভিতৰতে থব পেপাৰ পকাতে দি থোৱা আছে তাত কমপ্লিট কৰি দিছে এইটো
I'm being item number 6.
FIR is case 9 million.
FIR is just page 9.
9.
Yes.
I'm reading million. With reference to the subject, I have the honor to inform you that 21/4/2025 at so. Information was received from a reliable source that one Amjad Hussain means the petitioner. Of Posim is a Girukabari has been running an illegal oil theft racket from a Girukabari and Goramari area. Upon receiving the information, I informed the senior officials on so. I, along with staff, arrived at Posim Girukabari under Manipur PS. As per information, we found 2 vehicles vehicles, one Tata Indigo bearing registration number so and so, and another vehicle, Swift Desire registration number so and so, in front of the house of Uzair Islam, son of so and so of Pasim Gerugabad. Uzair Islam was also found on the spot. Upon interrogation, he stated that he is the driver of the Swift Desire and also stated that one of the car was loaded with 90 empty plastic gallons, and the other Swift Desire loaded 9 blue colored plastic gallons of diesel, each containing 60 liters according to so and so. One Tata Indigo bearing registration number, white color Swift Desire, blue so and so, registered under section Milot 3032 BNSS and read with section 23 Petroleum Act. In this case, Milot 23 Milot, it is the available offense Milot, 1 month punishment Milot. And in this case, Milot 3032 Milot, that is the theft Milot, punishment 3 years Milot. In this case, notice has not been issued Milot, rather the police threatening to arrest Milot. A petitioner nowhere connected in this case on the basis of the co-accused Milot stated that the session Milot, and police is threatened to arrest Milot. Milot, as per Petroleum Act Milot, without license Milot, as per section 7, Milot, can stored Milot 45,000 class B petroleum Milot, that is Milot diesel Milot. And assuming but not admitting Milot, petitioner is not a license holder Milot, he is not related Milot in this case Milot. As per
Who is
section
he? Actually, Amjad Hussain. He is
Amjad Hussain,
FIR
the
name, right?
petitioner.
No, his name is there in the FIR.
Yes,
I think.
only name is there, but Milot seized from the Milot Uzair Islam Milot in
He is
front
a
of
driver.
his house.
He is the driver.
Yes. He is the driver of the Swift Desire. I am not the owner of this vehicle.
You are not the owner.
No, I am not the owner. In the meantime, my lord, I may be protected. I will record the statement, my lord. Police. As per Petroleum Act, my lord, section 7, my lord, allowed 47,000 B class petroleum product without any license, my lord, can store, my lord. And section 23, my lord, which is available, my lord. And
Is there any explanation? Those empty, some gallons were empty and some gallons, they
Yes.
were 60 liter in each gallon.
yes, my lord.
So those were carrying in 2 vehicles.
Yeah, two vehicles.
No, you are saying that you are not the owner.
No,
of
no,
the-
I am not the owner. I am not the owner of this vehicle. And Ratan Miller, and the police not issued any notice under section 30.
Yes, what is there in the
Lordship.
arrest memo?
Lordship, in another 2 persons who's been named in the FIR, Lordship.
Hmm.
And the co-accused has already been arrested, Lordship. He's at base 14 and it's a 2.
Hmm.
Lordship come to when they come to ground of arrest,
Hmm.
when that was, it's Lordship.
Count of arrest.
Yeah.
Huh.
During investigation, it has revealed that the accused person, namely Uzair Islam, who is the FIR name accused person along with the present petitioner, and Munaf Ali and Amjad Hussain, the present petitioner, all are involved in illegal importing, transporting, storing, selling of petroleum oil in areas of the sun. Since one person is arrested, Lordship, this is an anticipatory bid. Lordship may call for the case diary at this stage without giving any interim protection, Lordship. That's how.
Miller on the basis of co-accused Miller.
One person will be
Co-accused
arrested,
implicated Miller.
Two non-
I am on the law point Miller. As per section 7 of the Petroleum Act Miller, without any license Miller, can store 45,000 of liters.
No, that is there.
And there is a
It-
Miller.
but
And
that
as
is
per
there, but the
section-
question is,
section- Miller, nobody
is
nobody
how
filed any-
illegally or illegally you have been transporting those these
Maybe not in
petroleum
this
products.
case, Milord.
That's the issue.
Milord, in this case, Milord, in this case,
Petition
Milord,
for sure.
in this case, Milord, nobody filed any complaint. Nobody filed any
No, you are
complaint.
dealing
For
with
has-
business. Who will file
Those
complaint?
petroleum product is stolen, Milord. No, Milord. As per section 7, Milord, and section 23. So 23 Petroleum Act is available, Milord.
No, that is
Yes, Milord.
understood.
And section 379, earlier 79, and Milord, 303.
See,
Milord, that is the 3 years maximum punishment, Milord. Police without issue notice, Milord, threatened to arrest Milord. Run after them.
Everything also. That is
In the
called for
meantime, a petitioner may be directed to appear before the IU. He is ready to cooperate with the investigation.
on a very reopening, Lordship, on 15th, 15/7. It's anticipatory bail, Lordship.
I have no objection, CD may be called for Milot in the meantime,
Without
I
granting
may
any
be protected.
interpretation.
Police.
Also, same
Is
allegation
379
is-
maximum punishment is
the
3
person
years.
is
Milot.
not
My
has been
lord,
arrested.
any commission
person
offense,
is
my lord, the
appearing
police
for
have to
anticipated
issue notice, Milot. That is
No,
not.
one may be arrested, that is different.
Yes.
thing.
Yes,
The
it is.
question is
Same
that he got
allegation,
arrested, definitely
allegation.
there may be
And
some
the
reason.
thing was.
CD will reveal everything, Lordship, thereafter may consider. Lordship.
As CD may become, I have no problem, Milot. In the meantime, I may be protected, Milot, as per case of the death of Milot. And 379, my lord, maximum punishment 3 years, my lord. Police have to issue notice, my lord. And that was not done.
Heard Mr.
Yeah, ma'am.
A.M. Ahmed, the learned counsel for the petition. And also heard Ms. S.H. Bora, the learned additional BP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so.
Yeah.
It is submitted by Mr. Ahmed that the present accused petitioner is no way connected in the alleged offense. He is neither the driver of the vehicle nor the owner of the vehicle from where the alleged petroleum products the petroleum products alleged to have been recovered. First. Partly he submitted there is no any allegation or complaint made by anyone till date regarding the theft of any petroleum product. Thus, the section 3032 BNS is also not attracted against the present petition. However, the petitioner is ready and willing to cooperate the I in further investigation of this case if he is granted with a privilege of interim pre-arrest pay. Further, Mr. Ahmed submitted that though the cases though the penalty of penal provision of section 303 subsection 2 BNS is below 7 years, but till that the petitioner has not received any notice under section 35(3) BNSS from the investigating authority. Investigating authority, and hence he has the apprehension that he may be arrested in connection with this case. And accordingly, the present petition has been filed. Next para, MS Bora, the learned additional BP submitted in this regard that CD will reveal the actual fact of the case. And in the meantime, he submitted that one of the co-accused has already arrested in connection with this case, and from the grounds of arrest made in the arrest memo, it is since that the present petitioner is also involved in the alleged offense. Considering the interest submission made by learned counsel for both sides, I find it if it is good. Okay, will be under interim protection. When it can be called?
Lordship, on 23rd.
23/7, there will be some observation, abide by all conditions.
I think 12.
Bail hearing, so I lost position to take up the bail hearing, in fact.
Lordship.
Other issues are also there. Anyway, yes, it is a fixed matter. Yes, want to submit anything?
The lordship, the CD was called for today's 37 days, lordship, the intermediate quantity, lordship.
37 days, yes.
Lordship,
Recovery,
otherwise, recovery is from the conscious position of the present petitioner, Lordship. And till date, Lordship, FSL has not been received, and the ground of arrest is also given by submitting the notice under section 47 of BNSS, Lordship.
So these will not come here.
It will not come.
Now,
here.
otherwise, your petitioner is in behind the verses 37 days.
37 days.
and the fitness, the lordship, the
Lordship.
wife is arrested earlier, lordship. The says, the suspected erroneous recover from the wife, lordship.
Let the FSL report
Yes.
come, Lordship.
Base lordship 23, lordship. The signature is there, Rufida Hatumi. Length of detention,
No, whatever, now, if you do give any date
Lordship.
for after vacation,
After
it will
vacation,
better.
very reopening, Lordship, on 14th,
Then he is on 37 days now behind the bars.
Lordship. Or any vacation
Vacation, no, we're not good fix, we don't know anything.
Length of detention, Lordship, consider the
I'm
edict
opposing
person,
it,
Lordship.
because it's a anti-social crime, Lordship.
Definitely.
Yes, it's an organized crime, Lordship. Otherwise,
Zero.
12.6 grams of suspected heroin.
14 will cover
Lordship, I think,
your 60 days cup free.
it'll cover. It'll cover, Lordship.
And what about the other submission from your CD?
So it is recovered from the conscious position of the
Conscious
petitioner.
position.
Yes,
But
Lordship.
FSL is not here.
FSL is not abated, Lordship, still. in it.
By the, I mean, as per the metro from the metro in the case diary, it's not a case of submission.
Not. Anticipatory. Let it be on 14, Lordship.
Heard Mr. N. Ahmed, the learned counsel for the petition, also heard MS SH Vora, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Ahmed that the Billy Malik, like his petitioner is behind the bar since last 37 days. And hence, considering his length of detention, he may be enlarged on bail. To stop in that context, MS Bora, the learned additional PP, submitted that the FSL report is not yet received from the investigating authority. However, the CD reveals sufficient incriminating materials against the present petitioner. Considering this submission made by learned counsel for both sides, let the matter be listed on 14/7/2025.
Lordship, in vacation court, Lordship, any date, Lordship, any vacation court, Lordship.
Oh, no, we are not giving any burden to any vacation court. It is not proper. It is not proper.
It's
To list the
47
matter
days.
before any
The
vacation
recover
bench is
from my
not proper.
wife, Lordship.
Huh?
Recovery from my wife,
Because
Lordship.
vacation bench only motions matters will be there, I think.
Probably, Lordship.
Probably. Hmm.
Let it be on 14, Lordship, because it's a intermediate quantity and it is recovered from the conscious position of the
No, no.
premises of the house. It's
The,
the
my
premises
wife,
of the
Lordship,
prison.
with the face, Lordship, 22, Lordship.
Okay, 14/7 will cover the cover up.
Yes, Lordship.
In vacation.
Or otherwise, list accordingly, we'll mention you make a prayer before the registry, so that it may be listed in the vacation bench, because I am not, I don't want to put any pressure on the vacation bench, because there will be 100 and more than 100, 200 cases will be fixed. So we do not want to put the pressure on the vacation bench, whoever may be there. So we will pass the order list, list after 1 week or 2 weeks, list accordingly. List
Registry will
according.
do the needful.
List according, and registry will fix it as on a date to be fixed by the registry.
Lordship,
So if it is fixed in the before the vacation bench, then well and good. Okay.
Lordship, CD has to
CD
be
may-
received,
CD has to be written, CDP written.
only the FSL report.
Yes, and the learned additional PP will call for the FSL report. And also will take instructions in regards to the stage of investigation. Okay.
Obliged, I know.
13.
No one is here. 13, what is the position?
13
13?
Lordship, also commercial quantity, Lordship. As on today, 94 days behind the bar.
Not yet charge sheeted.
Not yet, Lordship. Investigation is still going on.
Investigation still going.
Yes.
None appears on call for the petitioner. List the matter after vacation. Then list the
They
matter.
give it that
record.
back.
CD was sent back. You give return
Yes,
back.
because
This
yes.
list after vacation. CDB return accordingly, calling an updated one. Okay.
Lordship fixes any date
After vacation,
on at 21. Lordship. Okay.
21/7. Yes.
14.
The petitioner was arrested on 11/3/2025, my lord.
11/3/2025. Yes.
Last 106 days is behind the bar in connection with Vishwanath Shailee case number 53 of 25 under section 21C, 25 and 29 of my NDPS Act, my lord.
So till now he is 106 days.
106 days, and I have taken the ground of my lord, non-furnishing of grounds, my lord, and a PPS, an extra CPS 15, my lord.
Age
PS 15, my lord.
15.
15. Section 147 of PNSS has been violated, my lord. And in view of my Supreme Court decision, the Bihan Kumar, my lord, I am entitled to get bail, my lord.
This is 47.
Yes, my lord, 47.
And then
So
this
no
is
ground has-
47 and 48 is there.
It is there. 48 is okay.
48 is, it's okay, my lord. 47 not.
Whether 48 was also issued to the family members or not. Is there, Mr. Das?
It is there.
So basically your contention that the no grounds of arrest was been communicated
Yes.
while issuing 47.
So violation of Article 21 and 22, one also, my lord. And in view of those judgments, my lord, I am entitled to doing. It also already granted many cases now.
It's not clear, right?
Should I place some judgment or not necessarily? Your lordship has already, your lordship judgments are with me, my lord.
So he is behind the bar since 106 days, na?
106 days, my lord.
Still under investigation.
Yes.
FHL is pending, lordship, and materials are there, lordship, sufficient materials are there otherwise. And moreover, lordship, if we look into the
Sufficient? Sufficient materials.
sufficient materials are there.
Hmm.
However, kindly give me 1 minute, lordship. I have seen one order sheet of the lower court, lordship.
Yeah, I have an next, my lord. I have an next, my lord.
That it is stated that when 47 has been complied, written by the magistrate lordship, and it is also stated that stated that whether he will engage or not, any advocate. He has stated he will be, his advocate will be engaged by his family member. So well aware of the grounds and everything, lordship. And moreover, here grounds and it is non-bailable, it is already stated here in the 47 statement, lordship.
Who is the
And the
order of the
commercial
magistrate order?
Minister, I have the next, my lord, special judge order, my lord.
Where is he?
Yes,
The,
page 18, my lord. Page 18, my lord. It is only because investigation is on my lord. Because this ground was not taken before him, my lord.
On this
47
one,
ground was
this
not
one.
taken, my lord.
he was produced only.
Yes, yes.
Moreover, one thing is also there, lordship, there is one notice of 50A.
Already say here.
This is the order, lordship, and one notice is also there, 50A, in which everything is dated there. 50, I will. On the same day, 10/3, when he was arrested.
Huh.
That is also there. I will look in, go into that, lordship. Lordship may kindly look into the order sheet. 10/3, arrest policy. 2020.
They should have mentioned in arrest memo, my lord. It is so, they have given it, my lord. What was the difficulty in mentioning in the arrest memo, my lord?
First line of the next page, lordship.
So he will engage family members.
He is well aware of what sections are there. That is why when he was asked, that he has stated that he will engage by the advocate will be engaged by an advocate
not
of the
submitted in
family
the
members.
application, my lord.
And moreover, 50A is also there, lordship. May kindly look into the 50A on 10/3/2025, lordship. 50A notice is also there under NDPS, lordship.
It will
It will deduct monthly. So he is well aware of it. I will look into it. On the same date when he was arrested, 10/3.
This is 50, again 47,
50 is of NDPS, lordship.
50
NDPS
NDPS.
Act for SARS. So he is well aware why he was arrested, lordship.
Within
And he
47
was
has to
also-
comply, my lord.
he was
Ample
also-
submission, my lord. Maybe NDPS Act it followed, but it 47 has to be followed, my lord.
Otherwise, rigors are also there, 37. 37 is there. I only want to point on the focus on the point that Lordship, he is aware of the facts of the case, why he was arrested.
Maybe mentioning sanctions will not do sufficient, my lord.
Moreover, he is in his possession. These things are found, Lordship. Morphine was there. It is a
Yes.
commercial quantity.
Suspected part.
FSL is not there, Lordship. I am understated that it's pending.
No, here it is written,
Lordship.
whereas there is a reason to believe that a narcotic drug, oblique psychotropic substances, oblique controlled substances, or documents, articles, and things which may furnish evidence of commission of an offense under the NDPS Act 1985 are in your possession. Therefore, your personal search is to be conducted.
Lordship.
That much only. Okay. Fifty. Otherwise, materials are there.
Materials are there.
We'll pass the
Section-
order.
Look,
Yes. Any other submission?
And section 37 is also there.
37 is always there.
Look.
Yes. Okay. To wrap up, you will come to my chamber. I'll give it. Okay. next.
May it please your lordship.
Yeah.
Lordship, the petitioner is behind the bar for the last 938 days, lordship. 3 grounds I have taken, lordship. First of all, lordship, the section 50 notice, lordship, no grounds of grounds of arrest mentioned, lordship. Kindly peruse the notice, which is at the record, lordship. I have flag mark in, lordship. I have flag mark it in the record, lordship.
So in TCR, here you have flag mark.
Lordship, in the record, I have flag mark.
Yeah, this is-
record. On that flag mark, lordship. Record to duty. One is inspection memo and another is notice under section 50, lordship.
Bora, most probably here it is the case of 30-10-2022.
Lordship.
So prior to Pankaj Bansal.
Yes, lordship.
So your submission on that regard will be recorded, I think.
Yes.
Because otherwise in 2-3 cases, numbers of cases I have already recorded
Yes.
those submissions. Most
Yeah.
probably that will be one of the submissions.
Yes, lordship.
That will be recorded. And apart from that, you are in
Lordship, and second part is kindly peruse the inspection memo, lordship. Which,
petition.
lordship, arrest memo, lordship.
That is not relevant, lordship.
Lordship,
Case of 2022.
no, arrest memo, lordship. Arrest memo, lordship.
Yes.
No signature of the witness was taken, lordship. 3 days. Lordship, in this regard, I have submitted several judgment, lordship, with regard to notice and with regard to arrest memo, lordship. Recently, Division Bench of Calcutta High Court had passed in the judgment with regard to arrest memo in case of NDPS case, lordship.
And otherwise, your petition is behind the bar for 900.
900 and lordship 38 days, lordship.
What is the position of the case?
Lord, 3 witnesses examined, 4 is yet to be examined, Lordship.
Means trial is still going on.
Lordship.
How many witnesses are they cited?
3, Lordship, there is in the
No, no,
report.
3 already examined.
Lordship.
How many witnesses
Total
cited?
7, Lordship.
Seven.
Total 7, it is in the search sheet, Lordship, page 27, Lordship. Yes, signature.
We could be just when this one.
Okay. Lordship. So basically 3 grounds I have taken. One is notice, another is arrest memo, and third one is following incursions. I have placed the judgments, Lordship,
Yes.
along with the paragraph, Lordship.
Okay.
Oblige, your Lordship. And Lordship's judgment is also there, where Pankaj Bansal was discussed.
একটু স্কুল টু আনিস একটু
Lordship,
একটু
actually,
রেকর্ড হলো স্টুডিও
we also require the judgments that my learned friend has submitted before your Lordship, so that we can
Okay,
go through it, Lordship, because
submit.
without going through
Just
it, it's
submit it,
difficult for us.
Lordship. Oblige, your
So
Lordship.
basically your division bench judgment of Kolkata High Court was there. Or
Lordship. On
what it says,
on arrest memo, Lordship.
or in regards to the signature of the witness.
Lordship,
Most probably that is the point.
Should the, those.
I will submit, Lordship. I
Yes,
will
submit. Okay.
Lordship.
Provide to us, so Lordship may fix it on the very reopening, because we have to give our answer to that legal issues, Lordship, if it is required.
Lordship, my part is forward. Lordship.
No, for if you want to for further hearing it, if it is to be fixed,
Lordship.
then
after
you want to submit anything in this
Yes,
regard.
it, ma'am, what kind of judgment, in what manner they have
Lordship,
submitted
they
the
can
judgment
place
that I.
it now also, Lordship, if required, Lordship. Because this is a common judgment, Lordship, because already discussed in several cases, Lordship. This is a common judgment already discussed,
No,
Lordship. One
Bihan
is
Kumar
Bihan Kumar,
Purkayastha
Lordship.
is already there.
B. Purkayastha is there, Lordship. Then Kanishk Sinha, Lordship, with regard to
There is there.
retrospective operation, Lordship. Then Subhash Sharma, Lordship. There's already discussed judgment, Lordship.
He
Not new
only,
judgment.
these
Only
are the
Kolkata
judgments we are perusing are most probably reflecting in the many orders.
Lordship,
Lordship.
But the question is that the one division bench matter has been fixed, placed
yes,
of the Kolkata High Court, wherein
regarding arrest.
the
memo.
regarding the arrest memo, the
signature of the
signature of the
witness.
witness is not
Yes.
there. That much only.
That
You have
Lordship,
to submit.
Lordship. Oh, addressed.
Oblige, your Lordship.
And the rest is the prolonged incarceration is the one of the ground.
Lordship.
Oblige, your Lordship.
I'm sorry, Lordship. I don't know what 13 Lordship. I was there in court number 18 Lordship.
No, we are not in a position to hear now. We are fixing your date now. Your petitioner is behind the bar since when?
Lordship, more than 90 days in custody, but I'm facing Lordship.
No,
because
no.
One of the prime acres has already been granted on the ground that Lordship. The IO has not complied
Okay,
with the.
we'll furnish, we'll fix it next reopening day on 14th, 14/7. Because we have some other works also, 14/7.
Maybe on day after tomorrow, Lordship.
No. Day after tomorrow, we have other issues.
More than 90 days then custody. One prime acres, Lordship.
90 days mean what kind of matter?
No,
will
the
be tested?
NDPS matter. Lordship, on
NDPS,
it.
yeah,
But
yeah.
Lordship, what happened in this case, Lordship? All the court case has been granted bail by this.
So you want to withdraw this one then? You can withdraw and file fresh before the
but
learned
then-
trial court. We don't have any time
Honorable
actually.
Court- This honorable court has granted bail to the prime accused Lordship, on the ground that Lordship, the IO has not complied with the section 48 of the BNSF, Lordship. I am also taking that plea, Lordship, that I have never served Lordship, that 48 notice, Lordship.
We are
This
not
is
fixing, we cannot fix any date now. Actually, we are asked the registry not to fix the hearing matters because division bench is also there. So, but
That is true,
somehow
Lordship,
they
but-
have fixed, I don't know.
The your Lordship has granted bail on Kishore Ghosh, Lordship.
No,
He
no,
has,
whatever.
though he has furnished Lordship 48 BNSS, but in regards to the present petitioner's Lordship, the IO has never furnished any BNSS 48 notice, Lordship. So on that count only, Lordship.
No, we cannot pass the order now. You are on 13, na?
I'm 13, Lordship. I'm 13. I was there in court note 18, Lordship. That's why I could not appear.
No,
Lordship.
whatever. I do. You are on the other side.
But why doesn't
Who is appearing? State is appearing
is
here
that, so-
in item number 13.
13.
We are not in a position to hear any matter, in fact.
Lordship.
So we are fixing it on 21/7 in fact, otherwise. It is not a charge sheeted case, I think.
Not charged case, Lordship. The
Still
case
under
is,
investigation, still under investigation.
it's still under investigation. Lordship.
List tomorrow. Go with list tomorrow. Okay, list.
Lordship. I'm obliged, Lordship.
After we offer Lordship, this is a commercial quantity. Excuse me.
Excuse me, he is asking something.
Commercial
No,
quantity.
he is taking another ground of
Yes,
ground
yes.
furnishing, I think.
Yes, Lordship.
Otherwise it's a commercial quantity.
Ground of arrest.
I'm taking
No
note
doubt.
that I have not compared with section 48 of the BNSF, Lordship. On that ground,
Otherwise,
was a prime minister granted bail, Lordship.
Otherwise, Lordship, section 47 is duly complied.
Duly
Yes,
complied.
not,
Yes,
because of that,
that is
Lordship,
it.
48 not complied, Lordship, the one prime minister granted by this honorable court bail, Lordship. 48 not complied, Lordship. I have never been served, Lordship, even not served, Lordship.
Once Lordship
48
47 is served,
48 notice has not been served. But this person, what is your Lordship granted bail, he has been served 48 notice, but not complied, but I have not, never been served any 48 notice, Lordship. That's my ground, Lordship. Tomorrow, Lordship.
We are listing it tomorrow. I don't know when we fetch it. Okay.
I'm obliged, Lordship.
On 16.
এটা রেজিস্ট্রেশনটা খবর করি।
May it please your lordship.
Yes.
Your lordship, in this case, the accused is already behind the bar for the last 4 years, 2 months and 20 days.
4 years.
4 years, 2 months, 20 days. Charge sheeted matter, 4 witnesses has been done, has been cross-examined. The last witness appeared on 21/10/2024. All the other co-accused has been granted bail by this honorable court. On last 18/11/24, one of the co-accused was granted bail. And at that time, only 4 witnesses were examined. Till date, only 4 witnesses has been examined. No witnesses has come till date. So on the ground of long incarceration, I'm facing my bail taken. I have the copies of all the accused person who has been granted bail by this honorable court. And supporting my case, I'm giving Mohammed Muslim and Ravi Prakash case. On the grounds of long incarceration, already he has been behind the bar for the last 4 years, 2 months and 20 days.
Swapna. Item number 16. 4 years, 2 months, 2 days. 4 witnesses examined till date. How many witnesses, listed witnesses?
Listed witness, your lordship, 10 witnesses.
Out of 10, 4 only examined. Last witness was examined on 21/10/2024. Hekita has a long incarceration. Long incarceration, question to answer. Your ground of long incarceration. Because, yes,
Lordship, we could not file our objection, Lordship.
pardon?
Lordship, we received objection today, Lordship. We filing today, Lordship, matter may be fixed day after tomorrow, Lordship.
No, day after tomorrow is not possible. Tomorrow also 20-30 matters have been fixed in spite of having division bench. What to do? We don't have any time.
Your lordship, already long incarceration is there. So
Yeah, you want to submit verbally also, you can submit if anything is there. Because we cannot list it tomorrow, we cannot list it day after tomorrow. It will come after the vacation only. No issue.
After vacation.
After vacation will.
lordship may grant me bail because already all the co-accused has been granted bail on the ground of long incarceration. I have submitted the judgment of the honorable court and I have also submitted Ravi Prakash and Mohammed Muslim case.
It was
All-
last fixed on 12/6.
Yes,
So today is
today is
25th.
25th. your
Then
lordship.
you got 13-14 days time in fact.
And already your lordship,
Sir, is leave, Lordship.
No, what to do?
already your lordship, the NCP has failed to bring for witnesses before the court. So therefore, Lordship may grant the accused person bail. He is already behind the bar for so many. It is not a case that
Yes,
they
what
will.
to say? Obviously, he is behind the bar more than 4 years. So he is taking the ground of long incarceration, but obviously you have the file to objection, but if you want to submit verbally also, we will record it otherwise.
So kindly pass over the meter for time.
Timing, we are not going sitting on this second half.
Lordship, verbally, Mr. Kyan will appear, Lordship.
When? Today?
Today, Lordship,
Today
if
to
possible, Lordship, either Lordship, day after tomorrow, Lordship.
we don't have any time day after tomorrow. Only all the matters have been listing, in fact. Some personal works are also there.
Only 2 items have been left. Only 2 items are left.
Tomorrow is again list is bigger than today, in fact.
My
Tomorrow we
humble,
cannot list it.
my humble submission is on ground of long incarceration to bail may be granted.
The specific this involvement specific involvement is there with you.
Your Lordship, he was the accused person was not present at the place of
No,
occurrence.
generally what we see that the NCB people, they used to give some specification regarding the involvement. We have seen earlier also. So this is with you have not received till date. You have not received
Objection. Lordship.
objection.
We have received, Lordship.
Then
Today,
Your Lordship, if you may turn to page number 22.
20.
22. Page number 22. There is a point in point number 52. It has been stated that only on the statement of the co-accused. Only on the statement of the co-accused, the present petitioner's name is there.
You can peruse your role. Which role played by your petitioner's name is?
Gobind sir.
See here, specifically those things are here, in fact.
One.
Here,
And he was arrested.
your thing is, where is the specific mention about his involvement? In which page?
Page number 22. Your Lord.
20?
22.
22.
Para number 52.
So Gobind Shah, the para number 22, here most probably his involvement is specifically mentioned. You see? Kakoti, you see there. No?
And it will be proof at the stage of the trial, Your Lord. Because it is the statement of the co-accused, which is not admissible at the time of trial, as per the Tufan Singh judgment. So at this stage, I may be granted bail. I will appear before the court on each and every evidence.
So you see, Ms. Kakoti, that one Gobind Shah's involvement is there in page number 22 of the petition in para 52. Particular involvement of this Gobind Shah. Specific role of Gobind Shah. This is
He has
not,
brought-
you have not, this
He has brought a different file.
Oh,
Lordship, actually, 2 cases, Lordship, Gobind sir.
for Gobind Shah.
Only his involvement is that much. That is the statement of the co-accused. Therefore, I pray before your Lordship, because all the other accused person there who has been granted bail.
Friday. Friday matters for actually নিদিব এটা Friday to আকৌ ৰেজ কৰিব লাগিব সব মেটাৰ লিখিব লাগিব কে কোলা বেকাৰ ৰাখিলেও নহব লেট আছে এইটো যদি মই Friday দিওঁ এইটো আহিলেওতো এতিয়া কৰিব নোৱাৰি এইটোৱে কথা ইয়াত নি কিনে এই দুটা ফাইল বেলেঞ্চ ডিভিজন বেঞ্চৰ পৰা আহি ধৰি আকৌ এইটো কৰা মুছলিম দিব Problem is with us in tomorrow, there are many matters have already been listed. And secondly, Friday we cannot because Friday also we have to rise by 2:45. But that apart, I have the division bench also. All the matters will be left over or will be deferred. That's why Friday, if it is fixed, it will not serve your purpose. At best 14 or 14/7.
Lordship may grant bail on the ground.
No, they want to submit something. No, what can we do? We have to give an opportunity to them also. They want to file their objection. Tell us what to do.
Lordship kind of fix it 14 July, Lordship.
14, but again, he will be behind the bar for more than, say, 20 days.
20 days.
Then again, at best 14, otherwise we don't have any alternative. Or before vacation bench also, we cannot keep any put burden on the vacation bench because more than 150 matters will be there. So it's not good also. And at that part, this time the vacation bench is most probably, I don't know, because most of the judges will be outstation. So that is also there. Let it be on 14/7. You are Mr. Gogoi? JK Bhuya, heard Mr. JK Bhuya, the Learned Counsel for the petitioner. And also heard MS Kakoti, appearing on behalf of Mr. S.C. Kyle, the Learned Standing Counsel and City. It is submitted by Ms. Kakoti that due to indisposed condition of the investigating officer, they could not file their written objection in this case, and accordingly paid some more time to file the written objection. I can fix it on day after tomorrow, but day after tomorrow, definitely it will be left over. There is no scope for taking.
We can do day after tomorrow. If it is left over, then
It will be left over only.
it will be okay then. The day after tomorrow. Because he'll be again behind the bar for many days.
Okay, then tomorrow, day after tomorrow.
Much of it.
Obliged, Lordship.
17.
Yes, yes.
Lordship 17, I could not go through the LCR, Lordship.
Actually, Lordship, there are three grounds I have. issued the
No, whatever they have could not go through the case record. Right? It is a charge sheeted case.
Yes, Lordship. And his
So your petitioner is behind the bar since
more than 18 months, Lordship.
18 months.
18 months, Lordship. And even Lordship, the notice under section 50 of CRPC at the time of arrest did not contain the grounds of arrest, Lordship. And
So you are basically on the grounds of arrest.
yes, Lordship.
And what other
Prolonged
ground?
incarceration, Lordship.
Long incarceration.
Sorry.
18 months cannot be considered as a long incarceration.
It
Anyway.
is languishing behind the bars for 18 months, Lordship. Actually, and moreover, Lordship, the main accused, that is Tapan Monte, already been granted bail by this honorable court. For the page, Lordship,
Commercial
36.
OTT, Lordship.
Page 36, Lordship. We had 15 listed witness, only 4 have been examined. Well, Lordship, on the
Page 36 is an order.
yes, Lordship, on that there also there are only 4 witnesses have been examined in the even now also there are 4 examined witnesses only
Out of 10.
yes 15.
15.
Yes.
Investigation is okay, Lordship, trial proceeding is going on. Lordship. This side.
So otherwise, in 18 months, 4 witnesses have already been examined.
Yes,
That
Lordship.
cannot be considered as a thing.
Yeah.
Yes. Otherwise, he has taken the ground of non-furnishing.
Yes, Lordship. We have
Where you have annexed this petty, notices and all.
no, Lordship.
You have not annexed. Then too, it will not be proper. Not possible.
Let us fix after.
That 14/7.
Yes.
Just immediately on the day of reopening, we are fixing it on 14/7.
Lordship.
You could have annexed the certified copies and all. 14/7. List matter on 14/7. TCR has already been received. List matter on 14/7. We're listing it on 14/7.
Yes,
Look after.
I do.
it.